KZSU-FM Stanford, welcome to another edition of Hearsay Culture. My name is Dave Levine. I'm an associate professor at Elon University School of Law, as well as an affiliate scholar at the Center for Internet and Society at Stanford Law School. We are back on the air after a 3-year, roughly, hiatus. We recorded a few new shows that I'm going to be posting on hearsayculture.com and through iTunes in the coming 2 weeks. But we are very excited to have on today Professor Eric Goldman of Santa Clara University School of Law, really arguably the nation's foremost academic expert on Section 230 of the Communications Decency Act. For those of you who are paying attention to the news, it is front page, top of the fold, to use archaic references to newspapers, news on May 29th, 2020, that President Trump has issued an executive order whose putative goal is to limit the protection that speech platforms like Twitter and Facebook have under what is known as the Communications Decency Act, Section 230. This is a law which some have argued is the reason why we have the free speech internet that exists today. It is the reason why we are able to post information, post content, post music, post video, and say the things that we may choose to say in a given moment on the internet, on a platform that allows us to be read and heard and seen by anyone with an internet connection. In other words, Facebook, Twitter, Yahoo, Google, and so forth, in many ways owe their existence to Section 230. As we'll talk about with Eric in a few minutes, what Section 230 does at a top level is prevent all kinds of people and entities from suing these speech platforms for things like defamation, for saying things or writing things that a recipient of a given statement doesn't like, and for a host of other claims. And to put it directly, what that means is these entities that allow for speech don't have to worry about being liable when someone says something about someone else that someone doesn't like. Like, for example, the apparent impetus for President Trump's executive order, the fact-checking of President Trump's tweets via Twitter, and Twitter's efforts to point out, in its view, the false or misleading statements made by the president via Twitter. On the other hand, there are many critics of Section 230, and not just, by the way, the President of the United States, but those that think that speech platforms like Facebook and Twitter should do more to remove hate speech, to remove dangerous speech, to remove speech that allows people to engage in illegal activity. And perhaps most famously and most recently, there has been a change to Section 230, which was passed a little over a year ago now, which actually forces, arguably, Facebook and Twitter and other speech platforms to act much more aggressively against those that post advertisements involving sex trafficking. So there is a lot of debate around the merit of Section 230, not to mention the current news involving the president and his efforts to limit the use of Section 230 by Facebook and Twitter to prevent them from getting sued. Lots of moving parts here. We really could not have a better guest for this topic than Eric Goldman. Eric is, like I said, a professor at Santa Clara University, a former director of their center that focuses on intellectual property and privacy and these issues. He is a prolific scholar, a prolific writer. He appears throughout the world discussing these and other issues. He blogs at his Tech and Marketing Law blog, which has been around, I think, since the dawn of the blogging internet, if not mistaken. I should also note, by way of transparency, that Eric is a friend. Eric and I have also worked together on Section 230 issues and have co-authored letters pointing out its virtues. I say that because I'm putting on a different hat today, not the hat of the advocate, but rather the hat of the journalist. And so my effort today is to have a full-throated and extensive discussion of Section 230, but also to ask those questions with which I might not personally agree. And Eric's expertise, of course, being what it is, he is able to take on all of these issues. So we are recording via Zoom on May 29, 2020. I believe, Eric, correct me if I'm wrong, that you are at your home in California. I am at what I euphemistically call the East Coast studios of KZSU, which means my basement office here in Greensboro, North Carolina. Thank you for joining us today.
Thank you, and congratulations on relaunching Hearsay Culture. I think we're all better for it, so we really appreciate the work you do.
Well, thank you, Eric. It's very gratifying to hear that praise, and thanks much. Let's start off because we have a pretty, it's a wide-ranging issue, and we have a lot of people in the audience. Let's start at the basics, which I always find interesting. Your involvement with Section 230, I think, goes back almost to its inception as a law now, about 25 years ago. Tell us about your connection to 230 and how you got involved in these issues.
I started practicing internet law in 1994, before Section 230 was enacted. And I started teaching an internet law course in law schools in January of 1996, also before Section 230. So I understood some of the practical and theoretical challenges that we faced on the internet before we had a law governing the issue. Section 230 says, as you noted, basically that websites aren't liable for third-party content. And that clean, elegant proposition gave a lot of guidance to us in the field as lawyers. We now knew what to do and how to advise our clients where we weren't sure before. We were making a lot of judgment calls and guesses. So as a practicing lawyer at the time Section 230 was enacted, the law answered questions that needed to be answered. As a scholar and as a teacher, Section 230 gave us a lot to talk about. How do we allocate responsibility between various players on the internet? Who do we want to be doing the socially valuable work to police and manage content online? And what incentives and disincentives do we need to create in order to do that? I wasn't personally involved in the drafting or passage of the statute. That happened as a part of a much more complicated process I wasn't even really ready for. But since the law has passed, I've been an advocate of it. And I realized very quickly how important this law would be to our community. And so I've been championing the benefits that we've been getting from the law since February of 1996. I started blogging in 2005, and I blogged almost every Section 230 case I've seen since 2005. So for the last 15 years, I've tried to be the chronicler of the news in the Section 230 community. What's going on? What are courts actually saying? And what does this mean for our community?
And that background is helpful here in thinking about what this law means. For those that are uninitiated, of which there could be many listening to this show, what is the import of Section 230 to the growth of the internet?
Section 230 does a number of things that sometimes are counterintuitive. First, Section 230 establishes a clean legal rule that entrepreneurs and startups can rely upon when making their investment decisions. They know if they build tools in a certain way that they won't have to incur the liability costs associated with a different legal regime. So as a result, it functionally lowers the barrier to entry for new entrants. And that's why we've continued to see the emergence of new major companies over time, that we didn't just have the leading incumbents at the time the law was passed remain the leading incumbents. In fact, most of the leading companies circa 1996 are either gone or no longer a leading enterprise. Section 230 actually enabled that outcome by preserving the flexibility for people to enter without incurring substantial costs. Another thing that Section 230 does that's counterintuitive is that Section 230 actually provides motivation and freedom for internet services to do the socially valuable work of policing against objectionable and harmful content. If they didn't have Section 230, they would choose one of two paths. They would likely take a much more aggressive approach to editing, which would pick up lots of lawful, socially beneficial content and would likely add time and cost that would reduce the overall availability of publication tools. Or they would take what is sometimes called the passive conduit approach. They would try to do as little as possible with the hope that the court would excuse the fact then that they didn't try and therefore shouldn't be accountable for what happened. Section 230 establishes that middle ground that says you can do a lot of policing and a lot of socially valuable editing work, but you're not going to be liable for if you make a mistake, if there's something that you miss, if there was a judgment call that's debatable. And so it actually spurs more socially beneficial policing work than we might get under different legal regimes. And again, that's counterintuitive. People think Section 230 is what causes the bad content to persist. It's actually Section 230 that acts as a brake on the overall volume of bad content.
So, Eric, let's think about now, fast forwarding, and we'll come back to the details of 230. President Trump, there we go. President Trump tweeted, there we go, yes. And I don't do any, as I told you, I don't do any post-production editing, so everyone can enjoy. I don't even know what that slip means. President Trump tweeted, and Twitter responded. Take it from there. What's the story that leads us to why we're discussing this today?
Well, Section 230 has generated a lot of heat, especially in the last couple of years. So there's already a fertile soil for further fracases over Section 230. But the flashpoint that triggered President Trump to respond aggressively was Twitter's response to one of his tweets. Now, as we know, Trump values his Twitter feed very highly. That's an essential part of his identity, and it's an essential part of his ability to continue to communicate with his voter base. He has also arguably misused that Twitter feed repeatedly over a decade plus. It's not a new thing that Trump has said. Tweeted out invective. He has tweeted out conspiracy theories. He's tweeted out what many people would consider to be lies. And Twitter has done nothing to date. They have insulated him from any consequence for his tweets. And obviously that's a make or break decision for Twitter. They know on the one hand that Trump is an essential part of their economic engine, and there's no way to distinguish Trump from, say, other politicians. So they can't really tackle the entire class of contributors to their site in an easy way because they are such an integral part of Twitter. On the other hand, people think less of Twitter because they keep letting Trump get away with ridiculous tweets that clearly violate Twitter's terms of service and in some cases violate the law. So Twitter's in a no-win situation, and they've just been as deferential as possible for so long, they finally decided that this is it. They have to do something. So they announced a new policy that they would, quote, fact-check certain tweets, and they fact-checked Trump. They said, one of your tweets is not correct, and we're going to tell the public that. But what Twitter said was pretty gentle. It said, get more information about what was effectively a voter suppression topic here. So they didn't call it a lie, although that's what triggered the fact check in the first instance. And all they did is gently tell readers, hey, there's some more stuff that might be relevant to you that might help you contextualize what your president just said. However, that is a wedge between Trump and his loyal constituents. Twitter has now come into that relationship and said, we're going to tell your most loyal subjects that you just said something that wasn't right, which is as threatening to Trump's identity as just about anything. There's very few things that someone could do to jeopardize Trump's feeling of safety than to get between him and his direct ability to talk to his loyal voters. And so when Twitter fact-checked him, Trump, of course, and we all knew, would blow up. The question is how. And his blow up was a 6-page executive order that's designed to teach Twitter and the rest of the internet a lesson.
And that behavior, of course, is something we've seen of this president. The executive order itself, I know, has several parts to it. Frame for listeners, many of whom are not lawyers, what the executive order purports to do.
There's a lot of detail in what is only about 2,300 words. So actually parsing it out requires a lot of explication.
Go ahead. We have the time.
Well, I don't go all the way in the weeds. But the general idea is that Trump wants to activate the federal government to look for ways to change how people apply Section 230 to meet what he thinks the rules should be. Now, in your intro, you mentioned that some people are upset with Section 230 because they feel like the internet companies don't do enough to police bad content. Trump is trying to actually object to Section 230 because he thinks internet companies do too much, that they shouldn't get in the way between him and the conversation he's having with his loyal base. By them interposing into that relationship, they're doing too much because of Section 230. Now, there's a series of assumptions that are actually demonstrably false. We'll get to that. But for now, just understand what Trump's trying to do is to change the way that Section 230 is interpreted to prevent internet companies from being able to do the kind of cleanup that we actually think is the whole reason Section 230 is on the books in the first instance. So it's a very counterintuitive move on his part to say, we want you to do less work because we want to have more free speech, and we also then want you to enable a lot of conversations that you, in your editorial discretion, don't really want to have.
Well, and the politics of this, are interesting, as you note, because at least up until this point, right, the president has simultaneously criticized social media and, as you point out, used it as his primary and in many instances only conduit, right, to the public. How do you reconcile those two, or can they be reconciled as goals?
This is one of the things that drives an academic like me bonkers. Is Trump playing a game of 4D chess where he's thinking 6 moves ahead, and he knows that by doing this and the counter moves and the counter moves or whatever, he's going to get to the right place? Or is he shooting himself in the foot? Now, in general, my presumption is that there's no 4D chess being played by the Trump administration. What you see is what they get. And they're just reacting to the problem du jour, and they're not thinking ahead to the 6 moves about what's going to be the end result. It is possible that if the executive order worked exactly as it's discussed, it would damage Trump's ability to actually do what he wants. That strikes me as the logical outcome from the executive order if it works. So when we say that, then we're so tempted to then think ourselves, well, he couldn't be doing something that counterproductive, could he? He can't be sabotaging himself, could he? And I don't know. I'll leave it to your voters to make that decision.
Right. We have an election. Let me ask you some. And after the break, we'll talk about Section 230. We're chatting with Professor Eric Goldman at Santa Clara University School of Law on KZSU-FM in Stanford. So as a threshold matter, is there anything illegal or wrong with Twitter fact-checking a statement?
No, and let's be even more precise about this. Twitter has the right to comment on the statements of politicians, and that right is guaranteed not by Section 230, but by the First Amendment. Were Twitter to be somehow sued for having interposed its statement that there's more information relevant to this tweet, its defense would be, first and foremost, the First Amendment. And that defense would prevail. We provide very broad protection in our society for political commentary. That's what Twitter did. And the First Amendment is going to protect that. So one of the many things that drives a guy like me bonkers, and you're trying to play neutral advocate, neutral moderator here, so you're not going to take my bait, but I'm guessing is driving you bonkers, is that Trump is spinning up this whole machinery to undermine Section 230, but it wouldn't change the outcome about the fact check. Now, it might change other things about Twitter, like it could eliminate Twitter. It could cause Twitter to decide to do no fact checking for other reasons. But the bottom line is that what Twitter did here doesn't create liability for Twitter. It's fully protected, constitutionally protected speech, and Trump can't fix that. There's nothing he can do to fix that.
And to be clear, you mentioned the First Amendment. Does the First, and I know this is a big question, although perhaps a simple answer, does the First Amendment apply to Twitter?
The short answer is yes, but let's be precise about that, because there are many different layers of the First Amendment here. So one layer is Twitter protected by the First Amendment for publishing third-party tweets? And the answer is clearly yes. There's no question about that. We had a case from the Ninth Circuit in 2019 that said that YouTube is not the government required not to censor its publishers. It is a private publisher protected under the First Amendment for its editorial discretion about what content to publish or not. Now, separately, there was a ruling from the Second Circuit saying that Trump's account was actually government speech for purposes of the First Amendment. So when Trump blocked people from being able to speak to his account through his account, to respond to his account so that they showed up in the commentary to his tweets, that was actually an exercise of government censorship. So the First Amendment applies to Twitter, and it protects Twitter's discretion, and it also might restrict the government's ability to use Twitter.
And so, slight variation on the question, does an individual have a First Amendment right to use Twitter?
Right, okay, so Twitter is a private publisher, and it has the freedom to speak and the freedom to publish under the First Amendment. It's protected in doing so. And because of that, it is not required to accept anyone's content for publication. Just like you're not required to carry any guest who wants to be on Hearsay Culture. You get to decide that. Twitter gets the same power to decide, we want to carry this content or not. And that's been a well-established rule in First Amendment jurisprudence going back 45 years to a case called Miami Herald versus Tornillo that said that newspapers can't be forced to publish content they don't want. That same principle protects Twitter in its decisions whether to carry content or not.
So then why is it that we need 230 in the first instance? And this kind of doubles back to my introduction, but I want to be clear about this. Twitter has the right to, I think most people agree, right? Twitter has the right to fact check, right? Individuals have the power, let's say, to use Twitter, right? Why do we need 230? What is Section 230 doing in that space if more or less people can do sort of what they want to do? Because, of course, let's be clear, in the context of the president can use Twitter also.
There are two main reasons why Section 230 is an important embellishment to the First Amendment. But let's just make sure your listeners understand the import here. So the Constitution is very difficult to change. It's bedrock principles that we don't want to be changed rapidly. The First Amendment is enshrined in the Constitution. It's foundational law. It restricts the government's ability to limit speech, but it enables the government to do more to protect speech, what I call speech enhancing statutes. The legislatures are free to say, I'm going to extend or add to the First Amendment baseline in order to encourage freer speech in our society. Section 230 is one of those laws. Now, why would a legislature do that? Why wouldn't it say the First Amendment is good enough? Now, Section 230 does two things that are important here. Even if the First Amendment protects Twitter's right to decide what to carry and what not to carry, it doesn't change. It wouldn't change if Twitter is liable for, say, a defamatory tweet posted by a third party. The First Amendment might say Twitter could be liable for that. Section 230 says Twitter cannot be liable for that. So by changing the liability outcome from the First Amendment, we actually do something really important in terms of Twitter's freedom to innovate. The other reason is that the Section 2 today provides some very important procedural protections that, though even if they don't change the substantive outcome of a case, they make the case cheaper and quicker for a defendant to resolve. Those procedural outcomes are essential for the startup and entrepreneurial value of Section 230. It lowers the entry cost by keeping those cases to be cheap and telling the plaintiffs don't even bring them. You're going to lose and it's not worth your time. So because of the procedural benefit and the substantive benefit, Section 230 does an important amount of work that the First Amendment never would do.
We're chatting with Professor Eric Goldman of Santa Clara University School of Law on KZSU-FM Stanford and Hearsay Culture. For those of you that listen to KZSU regularly, you know that KZSU is a nonprofit, non-commercial radio station at Stanford University that requires donations from listeners like you to continue its programming. Particularly in these hard times, it's important, I think, generally to support the free press and the media, and this is certainly, KZSU is no exception. If you want to make a donation, there's a couple of ways you can do that. You can email our underwriting department at underwriting@kzsu.stanford.edu, or you can go to our webpage and click on Donate to KZSU. Regardless, please do support the free press and the media during these times. So, Eric, let's go now, to thinking about more specifically what exactly Twitter did. So, Twitter, by fact checking, right, did what vis-a-vis Trump's tweet?
It simply told readers of that tweet there's other information you should consider. So it didn't rebuke or refute Trump's statement. It said there's more you need to know. But still, as I mentioned, that was inflammatory to Trump because it did add extra meaning to his conversation between him and his loyal base.
And look, again, without, I am not going to, by virtue of journalism, ignore facts that have been proven, right? The president has been shown to repeatedly tell lies and falsehoods. He's been called out for it, sometimes by his own party, but usually by the press and, of course, by the Democrats. To the extent that the president chooses to use Twitter as a policy matter, do you think it is in Twitter's best interest, we'll put aside the public for a moment, in Twitter's best interest to fact check the president?
Clearly, it is a known risk that if media enterprise allows politicians to have direct, unfiltered communications with their constituents, the politicians will lie. And we didn't see that as much in ye old days, pre-internet, because there weren't a lot of mechanisms for politicians to have direct, unfiltered access to reach a mass audience of their constituents. So a lot of times they had to work through the intermediaries of things like broadcasters or print journalists, and that filtering function that was done by the broadcasters or print journalists added some context to the politician statements that helped keep them accountable. They knew if they just said an outright falsehood that the intermediary is going to immediately present it as, here's this falsehood that just was done. That's the story. And that discouraged politicians from lying. There's no similar function that takes place when President Trump tweets. There's no doubt that there's lots of people who gang tackle him and point out the idiocy of his statements. And yet for his loyal voters, they are willing to just accept what he says at face value. Or they like the atmospherics. They don't care what the truth is or not. Either way, the fact-checking function doesn't work on Twitter the same way it did in the old intermediated days with broadcasters and print journalists. Because of that, then, what is Twitter supposed to do? If they do nothing, politicians like Trump will lie in ways that are pernicious to our society. Remember, this is our taxpayer-funded government lying to us. That's terrible. They can't let that happen. On the other hand, if Twitter tries to fact check, there are two problems. One, they're now trying to get into what Mark Zuckerberg has called arbiters of truth. And
Right.
Twitter isn't a great arbiter of truth. That's not their core competency. They don't really know how to divine the truth. They aren't in a great position then to rebut the lies. The second is that by doing so, by interposing themselves, they invite the blowback, like an executive order that says we want to destroy Twitter. When you fact check politicians, they have the ultimate power of retribution. They have the power to go and try and wipe a company or entire sector off the face of the earth. And so no company really wants to use that fact-checking power even if they have it, because they know that it's a nuclear war type situation. And that's exactly what happened. And I'm not sure if Twitter regrets starting off the war, but the government will finish that war, and it's not going to end well for Twitter.
Well, and that's kind of, we don't have crystal balls, but I do want to ask your expert opinion as to where this headed. I was running this scenario by my son Noah, and he asked me a really good question I want to ask you. So President Trump is a politician, the most powerful person on the planet, but Noah asked me, do you have to be famous in order to be fact-checked? In other words, could Twitter more or less start fact-checking everyone or every post? And if that's the case, what are the ramifications?
Well, so when you say they could, there's a bunch of questions
Right.
there. There's a legal question.
Right.
Do they have the legal power to do so, or will they be punished for doing so legally?
Particularly politicians versus others, right? Versus the average American citizen, let's say.
Politicians really don't like it when people tell them that they're lying.
Mm-hmm.
That's something that they tend to remember, and not favorably.
Right.
So we were saying, you were asking, could Twitter fact check everybody? So there's a legal question. Do they have the legal authorization to do so? And will they be sued out of existence for doing so? There's a technological and cost question. What would it cost to do that? Do they have the money and resources to do that? We all know the answer. Twitter in particular, it's not particularly profitable. So if they tried to incur much greater fact-checking costs, actually they probably can't run their business. The economics don't punch. And then there's a social question, or kind of a philosophical question. Do we ever really know what the truth is? And who decides what truth is? And how do we deal with the fact that when our government is supposed to tell us these are statements of fact, and we don't think they're actually telling us statements of fact? Now what? It's really awkward to call out our own government that we're paying to tell us the truth, that our money's being stolen from us. It's being misused for us. That's a really awkward thing for a private company, especially one that's not particularly large, to do. So could Twitter go and fact check everybody? Yes, they could, in kind of a platonic absolute sense. But would they? I don't see how that could possibly work, and I don't see why they would choose to do that.
Well, and that's kind of, and this is, I think, part of the president's criticism, which is more or less, who are Twitter to tell me that I'm lying? Of course, as you point out, that is a criticism that many presidents have had of whoever is calling them out. I mean, it's certainly, it would be unfair to say that that lots of presidents had a warm relationship with the press, although quite clearly we've never had a president that has literally and regularly called the president the enemy of the people. And any member of the press, putting aside whatever neutrality you want to take, has to take a strong position against that. Arguably, the entire country should. You posted and let's talk about the executive order in a little more detail in a moment. You posted a rather lengthy blog post just right before we started recording. I'm not going to pretend to have digested all of it. I haven't. However, I do have it in front of me, and I want to ask you kind of a big picture question from it. where both of us are law professors, obviously. We get into the weeds of the law. We enjoy getting into the weeds of the law. We probably shouldn't be doing this. We enjoy sharing our opinions. I jokingly always tell my students at the beginning of courses, my favorite part of the course is when I get to talk about myself. And so all of that aside, when we are talking about such a complex issue like Section 230, and one where, and I want to talk about this next, one where there are legitimate concerns, even if one may ultimately decide that the benefits outweigh the costs. How can the public be expected to understand these intricacies in light of all of the moving parts, not just with regard to Section 230, but with regard to society generally? It would be really disingenuous and I think not helpful to remind everyone of things that we are living. We are in the middle of a pandemic that this recording has killed over 100,000 people. A pandemic which it seems has been exacerbated significantly by this administration. And now we've got, today's news involving Section 230, which could easily be knocked off the front page if it hasn't been already by the next thing. What should we reasonably expect the public to understand about this issue in order to protect our general interests as a functioning democracy, not to mention speech? Should Section 230 be something that operates in the background for the average person, or do you think it's something that people need to take a much closer look at and understand in greater detail?
Yeah, Section 2 is so fundamental to our lives that it's something that we all actually do need to understand at least a rudimentary level. And it touches so deeply in our lives that it's impossible for us to ignore its impact on our daily lives. If you think about the services that your listeners use on an hour-by-hour or minute-by-minute basis, almost all those internet services are from Section 230. We're doing this call on Zoom. Zoom benefits from Section 230. We're talking about Twitter. Twitter benefits from Section 230. We use Google search engine. That benefits from Section 230. We shop at Amazon. That benefits from 230. If you run down the list of the most used websites on the internet, you'll find that the top sites are almost exclusively internet services protected by Section 230. And if you deconstruct your daily activity and say, wait, am I talking with somebody and could someone in the middle be liable for that conversation? You now know that you're benefiting from Section 230. The problem is that you have to untangle all the different dynamics here. You've got Section 230 enhancing statute, and not everyone's clear on exactly what the terms are of Section 230. And that sits on top of the First Amendment, a constitutional right that not everyone understands anyway. And then how do you put all that together? And then you get the rhetoric, and especially the misportrayals of Section 230, which are rampant and coming from people who know better. We've had multiple senators say things about Section 230 that are demonstrably false. They have to know what they're saying is not correct. But when they inject that,
can you give me a couple of examples of those, by the way, just for listeners' benefit?
I know. I hate to repeat them honestly because they're so odious. But people like Senator Cruz and Senator Rubio have both recently said that, Senator Hawley from Missouri have all. Basically, Section 230 applies to neutral services. If you exercise editorial discretion, you lose Section 230. And that's not been the law ever. We had a case, a leading that is not correct. So for 25 years, that statement has been wrong. And I'd like to think maybe they just don't know better, but these are extremely educated individuals with degrees from prestigious institutions, including law degrees. They know better. And so they're telling us misrepresentations about what the law says, and then your listeners will be outraged. Well, why the law? Why aren't the internet companies doing this? Or why should they benefit from this protection if they didn't meet the predicate assumptions that are actually not predicate assumptions, but really misportrayals of the law? So it's super hard for listeners to really get their ears around what Section 230 says. But come back to the basic principle I mentioned earlier. Section 230 says websites aren't liable for third-party content. And that's something people can really get intuitively. Go back and rewatch the Seinfeld series finale, which was basically about bystander liability. You can be liable if you're watching a problem and don't intervene. Wait, that doesn't really sound right to us. Like, wait, we're not the ones doing the problem. It's not our responsibility to go and fix that problem. That's basically Section 230 in a nutshell. It's actually really clear when people get to that level.
Your blog post, which I will post in show notes afterwards, and I recommend, of course, to lawyers, but I even recommend to folks that aren't, because at least the first part, before you admittedly get into a deeper dive, I think is digestible. But I do want to, and we've got about 10 minutes left, kind of talk about where this leads. So you reproduced a post from this morning where President Trump has said revoke Section 2. Well, they didn't say revoke. Excuse me, revoke 230 exclamation point in his almost trademarked all caps. Let's be clear about this first of all, and I'll spare you. The president cannot revoke Section 230A. B, I assume you agree, the executive order cannot amend Section 230. Moreover, and I don't want to get into the weeds of this, but just for thoroughness, right? The FTC and the SEC would have a difficult or impossible time acting under Section 230, much less getting into things like content moderation. I know that that's a complex issue, but am I generally right by saying that?
Yeah, right. So Congress passes laws, presidents enforce laws, and so the presidents can't say, Congress, I don't like your law, so I'm going to just rewrite it. Mm-hmm. That's not how it works.
Right. And so, despite that, and I'll just quote you, towards the end of your post, using what I know, because I read your material, your rarely sadly used meme of the dumpster fire. You have the final heading, Section 230 is doomed. And this, I think, is a reference to the broader state of play regarding Section 230, because as you noted, and I mentioned in the introduction, Section 230 has been under attack for a while. I want to get to this doom prediction as we close, but again, in the interest of thoroughness and fairness, there have been some, and to be clear, stellar and highly regarded and really brilliant scholars who have pointed out concerns about Section 230. Briefly, for the benefit of the listeners, if you would share or just describe the most recent amendment to Section 230, what is known as SESTA and FOSTA, but what it did.
SESTA and FOSTA is actually a super complicated law. It has six different moving parts to it. The broad brush picture is that it tried to eliminate advertisements or promotions that that featured sex trafficking victims. It also sought to eliminate advertisements for commercial sex generally. So there were two different levels at which the law tried to do that. And it did that by expanding the scope of some federal crimes, which Section 230 doesn't cover. I said websites aren't liable for third-party content, but there are some statutory exclusions, and federal criminal prosecutions are one of them. So they expanded the scope of federal crimes, which Section 230 won't touch. Then they excluded from Section 230 state attorney general prosecutions and civil lawsuits that meet certain elements that relate to promotions of sex trafficking victims or promotions of commercial sex. These exclusions then were designed to basically say, you need to get rid of all that content. And if you don't, we're going to unleash some new plaintiffs on you who are going to try and take you down for doing so. The result of that, though, didn't work exactly the way Congress thought. Congress thought, okay, everyone's just going to do all this extra effort, and they're going to make sure that there's no victims of sex trafficking promoted. And some services did do more. Other services have basically exited the industry and said, what you're asking for is impossible for us. It's not commercially viable for us. We can't accept or afford the liability for it. We're out. And whenever we shut down, we're taking down whatever illegal stuff that you might have been targeting, we're taking down all the legal stuff as well. By trying to create some new zones of liability that were no longer protected by Section 230, what it actually did then was counterproductively cause a bunch of domino effects that were entirely predictable, but weren't actually what Congress thought people were going to do.
But isn't it fair, though, Eric, particularly in light of what we know now, to be more than mildly annoyed that, and you're right, and I want to be clear, we're talking about Twitter here, Facebook's taking a different position, but that Twitter, for example, would choose to fact check the president, but not do more to prevent the use of its platforms to engage or allow for communication between those that are engaged in heinous and morally reprehensible and barbaric crimes like sex trafficking? Isn't there a dichotomy there that one could legitimately say, why are you picking one and not the other? And I know that Twitter is not the best example of this, but I'm just saying social media generally. In other words, why shouldn't we expect social media to do more anyway?
Well, I'm not 100% following there
Mm-hmm.
because that assumes that the services weren't actually doing everything they could to try and prevent the promotions of sex trafficking victims.
Mm-hmm.
There may be promotions of commercial sex where it's not clear that the person being promoted is a victim of sex trafficking. There can also be content that is implicitly but not clearly promotions of commercial sex. And so we don't know which of the millions of items of user submitted content are the ones that are actually the bad content. They don't
Mm-hmm.
come with a flashing neon sign saying, this is the one that you need to get rid of. If it came with a flashing sign, they would get rid of it. But to sift through the tens of millions of submissions to find the ones that might possibly be the violations and you're not really sure, you don't have enough evidence, there's only so much the sites can do to do that. And then at some point they say, I can't afford to go down that line. I can't be the arbiter of truth like we talked about. I can't figure out this. Or they say, I can't afford the cost of doing anything here. I'm out.
Mm-hmm.
So to say, why don't you do more, kind of misses the point. It assumes that the bad content comes through with the flashing neon signs, which it doesn't. And to prove that that the sites do more, usually the opponents of Section 230 will say, but you missed this one. This one out of this one, how could you miss this? To which the internet service will say, I'm sorry, do you want to go through the tens of millions of submissions that we got today and then try and make sure that you could have found that one in the process that we deal with? They don't understand how the content comes in a way that actually makes the anecdotes not really illuminating.
No, and in the last couple of minutes that we have, I'm going to ask some questions that are arguably unfair given the time we have. One of the criticisms of Section 230 these days is if Facebook and Twitter needed it, they don't need it anymore. They're giants. They have more money than God. Enough's enough. And the internet is mature. Your 30-second response to that critique?
Yeah, and I did write a short essay on that very one, actually short enough that your listeners might want to go ahead and read that, not the 5,800-word blog post on the executive order. The short answer is that, as I mentioned, Section 230 preserves the ability to enter the market with low costs. So if we were to reduce Section 230's protections, the existing incumbents have enough money to be able to afford a different legal regime, but the startups that want to challenge them don't. So if you want to get Facebook or Google, modifying Section 230 is actually the wrong direction. You're actually giving them a benefit, not hurting them.
Last pushback question before we close. Another concern that exists here boils down to these platforms themselves are engaged in just rank censorship, and they're not going to fact check Joe Biden. Response?
There are two things going on there. One, will they fact check Democrats and Republicans, liberals and conservatives equally? And each side has a huge stack of anecdotes to say, you took care of this one and I can find something similar on the other side that you didn't. That's the problem with making decisions between what content's fit to print and what isn't. You make winners or losers. The losers are always going to be upset that they got aced out in that process. So I don't think that that actually is the goal. The other thing I'll just mention, use the word censorship. I just want to make sure your listeners understand. Censorship is what the governments do. When private publishers do it, it's called editorial discretion.
And that, which is a huge, which sounds like to non-lawyers semantics, but actually is a huge difference. Do you think, in closing, that and you know, trying to get into the mind of anyone, much less this president, I admit is a challenge, but do you think the president has already achieved his goal? Right? If the goal was to, you know, draw attention to social media and put them on the spot, and you know, perhaps, given the fact that you're predicting that Section 230 is doomed because of all the activity here and where it's going, you know, that he can chalk this up as a victory. Even if, by the way, to be clear, even if the executive order is unenforceable and is challenged in court and challenged successfully.
Yeah, so President Trump has already won with this. He did what he is the master at. He has the ability to make the media cater to his news agenda as opposed to theirs. And so by going and challenging one of our cherished civil liberties, the media gets all spun up in a frenzy, covers this and doesn't cover other important things. Like you mentioned, the fact that we have many dead Americans only because the federal government didn't properly handle the response to the virus. He's also won because he's going to use this executive order to go and raise more campaign donations. He's going to go to his base and say, I'm fighting for you. The other guys aren't. Make sure that I win again. So the executive order never really was meant to change the law. It never had to in order to accomplish Trump's objectives.
On that, you know, certainly not optimistic, but that's the world we are in right now, Eric. No, I think it's fair, and I'm not, you know, I don't invite guests on Hearsay Culture to tell me, you know, tell my listeners what we want to hear. I think that's a fair assessment, and personally, not that it matters that much, I don't really disagree. Thank you for joining me on what is an exceptionally busy day for you. I know that other my colleagues in the press and others are reaching out to you. Thank you for joining me today on the show. I appreciate it greatly, and you know, I look forward to staying in touch, and of course having you back in the future. Hopefully not to discuss the end of Section 230, but perhaps new developments in our speech platforms.
Thanks for having me, Dave, and of course, thanks for everything you do.
Pleasure. Thank you, Eric. So, and you are free to go, by the way, as I close the show. Onto your next appointment. Folks, thank you for joining me today on the show today. As I mentioned, with regard to Hearsay Culture, I'm in the process of relaunching it and doing lots of, hopefully, you know, new things based upon the history of the show, you know, including trying to broaden questions. As always, you have a number of ways to listen to Hearsay Culture. You can listen this quarter during this very difficult time for the country at 8 p.m. Pacific time on KZSU in the Bay Area. The show also will be available, as it always has been, at hearsayculture.com, where you can listen to all, and I'm very proud of this, all of the 14 years of history of the show. You can listen to the show through any of the podcasting apps that you enjoy, as well as any other platform that exists to share this information. It's available additionally through Stanford CIS as a podcast. As always, I welcome your suggestions, feedback, thoughts, particularly as we move forward with the show, by emailing me at dave@hearsayculture.com. You can also email me at Elon at dlevine3@elon.edu, or by going to the webpage hearsayculture.com, where you can find all of the shows. Stay safe, everyone. You know, take seriously, of course, as many of us do, the world that we are in. But thank you for listening today. Please stay tuned to KZSU for more diverse programming, and have a great day.